right. Good morning, everyone. And thank you for taking some time out of your busy mornings to spend time with conversations around financial planning. I'm Greg Pettis. I'm a CFP, Certified Financial Planner. Just a quick little background on what I do, and then we'll jump right into the material and we'll start sharing some PowerPoint slides. But we're going to have as much of an engaging interactive forum as we can. I would encourage you to jot down a few notes, and we'll have a formal Q&A during about halfway through, and then at the end, we'll open it up for even more. But my role, I have two hats. I'm wearing the author hat slash lecturer. I'm co-author of this book on financial planning. It's the Smart Stepfamily Guide to Financial Planning with my co-author Ron Deal and attorney David Edwards here in Springfield. But I also wear another hat, but I'm not in that hat this morning. I'm a vice president of advanced planning at the Bank of Springfield here in Springfield. And I cover all of Illinois. We have branches all over Champaign, Bloomington, Springfield, Staunton, Shiloh, O'Fallon, Glen Carbon. So I'm all over the state. Would look forward at the culmination of this forum for us to have a chance to get together and talk one-on-one. Perhaps you have questions that are too personal to ask this morning. That's usually the case. And give me a call. We'll have my phone number on a link that you can contact me, and I'd be glad to sit down with you for a 1-hour conversation. So as a CFP with about 35 years experience, what I do not do is sell product. So everybody puts their guard down. I'm a fee-only financial planner. That's important. There are several other CFPs that are doing a great job, but they also charge commissions and sell product. But what I found is with a comprehensive fee-only venue, I can truly be objective. So let me talk about my 3 C's. The first C is I'm connective. I don't come to replace anyone that's already on your trusted team. So, many of you already have 2 or 3 investment people. You have an attorney, you have CPAs, you have other experts that you call your advisory team. I'm here to help connect. Because what I've found is so often the attorneys drafted documents, but, well, nobody has them. The CPA is advising for certain tax-oriented strategies, but the 2 investment people don't know what he's saying. And the 2 people are doing opposite things. They don't even know that they exist. And so my job is to come in as an objective, fee-only CFP and connect the parties and let them talk and help a cohesive connectivity happen. The second C is clarity. There are so many things happening, changing. I mean, we've got the OBBBA, the one big beautiful. Some people say don't say beautiful. Oh, all right, let's call it HR1. How about the new tax code? We've got that on the right here on our plate, and then you've got your Social Security Fairness Act and all the changes that are occurring with tax brackets, tax rates, and we're back to the TCJA days, the Tax Cut Job Act days. And so my job is to provide clarity. And I do that with customized plans. What I mean is 150 to 250 pages, all about you and your best financial future. I don't just focus on the wealth building. I will show in just a moment. I have 5 different windows that I look at and look in. That might be a good time for us to start sharing the screen. Let's jump into our material. These are financial planning conversations. This is going to be informal. I'll probably use a little fire hose method for about 20 minutes and open up for Q&A. I look at the window from 5 angles. So you might be interested in looking out a window that says, okay, here's my personal financial issues, here are my marital financial issues, and here's my family financial issues. You kind of divide it into those 3 categories. Others may come to me and say, look, I want to talk about me. I'm in my 20s. We just got married. We are individuals without children, but I want to help my young family when the kids come. And I also want to talk about my adult children one day. And then what do I do if I'm caught in the sandwich generation? So that's their paradigm. Others might say to me, Greg, I own a business, so I want to know something about the new OBBBA, but how does it apply to my business? Oh, and they both culminate in a legacy. Let's talk about that. Many people say, oh, he's a CFP. Then he'll talk about accumulating wealth, then preserving wealth, then distributing the wealth. And that is true. But lately, I've had several clients that had non-resident spouses. In particular, I'm working with a gentleman in another city outside of Illinois who has a wife from Ukraine, and she's not a U.S. citizen. So he wants me to look at, Greg, what are my domestic U.S. planning issues? And then what are my non-citizen spouse planning issues? And then let's take a look at global issues because I'm going to build a house in Italy one day. So whether you have a simple paradigm or you a complex paradigm, I work together with your CPA and attorney and current investment people as a second pair of eyes, at least, if not the quarterback, to help tie it together. So let's get started. When we talk about financial planning, I want to encourage everyone to first concentrate on the who, then the what. What I mean is, it's important that you have a group of trusted advisors. And I think the wise man once said, in a multitude of counselors, there's safety. And these have to be people that you've vetted. You might have even interviewed to find out, how are you compensated? Are you a fiduciary? Do you really have my best interest at heart? Or are you just trying to sell me a product? So that's a very important first step. Secondly, I will sit down with you and ask you to actually quantify numerically your needs. I give those 9s and 10s. Gotta have. I've got to have X amount per month for income, and I cannot negotiate that. And we want to make sure we have good, ample health care. Secondly, here are my wants. I want to go travel at 10,000 a year. I want to see my children graduate and go on to a master's degree in certain fields. I want to help my grandchildren one day. Oh, and then there's my bucket list. I wish that I could go to every single NFL stadium in the country one day, or I wish I could jump out of a plane over Connecticut or something like that. So we help you with that. We actually sit down and we want to have a marital unit. We want to have both spouses to sit down separately and talk about needs, wants, wishes. That's a discovery in itself. A lot of times, I didn't know you wanted that. Well, you never asked me. So it's fun. And thirdly, we're going to ask you to create a list of everything you own and owe. And in that list, it's not just who owns it, but how do you own it? You say, I own it jointly. Well, is that JTWROS or is that JTIC? There's a big difference between joint tenants with rights of survivorship and joint tenants in common. So we're going to dive deep on ownership. This is number 4 is a really important one. Even if you feel like, you can tolerate risk, the loss of principal is how I define risk in this case. That changes over time. You went through let's say you went through the dot-com bubble and you went through the 08 mortgage crisis. You were fine back in your 40s and 50s. Now we can't afford to lose 30%. So that needs to be reviewed. And then I'll help you to match up number 5. I match up your assets with your goals. And I'm talking about is what money do we take from first? What are the tax consequences of taking it from a qualified plan versus my Roth or a non-qualified jointly held account? And there are so many, especially in the step family, the blended family, number 6, there are so many hot button topics. I would help you to address those. I mean, for example, you bring up almost anything around child support, and it's gonna create a lot of emotion, eh? What I'm finding is that there are about 10 times more below the surface issues than there are above the surface topics. And I will do my best to help you to talk through the hot button topics. We don't have to address them all right up front, but over time, which is what I do, I build a relationship for a long period of time. We can help you to address your hot buttons. And accept number 7, there is no perfect plan. I mean, life throws curveballs at us, doesn't it? And you might have to just recalibrate. I mean, your needs, wants, and wishes today after a divorce may be completely different than they were prior. And his kids, her kids, our kids, what did we mean when we said, I do? Who gets the business? Who gets the farm? How do we do this? What does fair mean? So these are some of the things we do. And finally, number 8, we review and monitor your plan regularly. This is not a one and done. I said I provide about 150 to 250 pages of customized work, and then it opens a relationship that you could call in and say, hey, Greg, I've got this opportunity. What do you think? I'm being offered this product. What do you think? I'm about ready to move to another state. How does that affect me? Etc. Let's go to the next one. Here are some of the questions that I would highly recommend that we address. What are your short-term? We talked a little bit about long-term needs, wants, and wishes. That's where we start. That's the heart of our plan. Who's in charge if I'm sick or disabled? Both who's in charge with my money and who's in charge of my, medical treatment. We'll talk a little bit more about powers of attorney, durable powers for finances, and power of attorney for healthcare. What are my finances going to look at the time of my death? Do I have enough survivor income for my wife, my husband, my loved ones? And when and how do children inherit? When and how do stepchildren inherit? Who's in charge of the children and finances after my passing? Have I coordinated my beneficiaries and those designations on my 401 and my retirement plan and all of those things, my IRA and the annuity? Have I coordinated those designated beneficiaries with my will? Because those beneficiary designations are in essence, they're wills in and of themselves. They bypass the will. You might say, I hereby leave all of my assets to my beloved, but you've named other people on your beneficiary lines, and beloved doesn't get anything. So that's an interesting dynamic. We have to coordinate. And then what about the house? These are specific items that often are some of the largest assets in our lives. What about the house? It has some emotional underpinning there. That's where I was raised. Who gets that? What about the farm? I have one son that's farming. I have 2 daughters that are not interested. What does fair mean? The business may not be a big deal, but if you put your blood, sweat, and tears into it, you want to make sure the right people are going to take over your business. And then trust. I'm going to move into wills and trust. Well, let's go on. We were talking about questions to address, and it leads right into documents. The foundation of any good financial plan is going to have a cornerstone of estate documents. And when you think about it, only about a third to a half of Americans have even a will that's updated. And the will is a cornerstone of a good financial plan. And in addition to a will, a durable power of attorney, both for finances, who's going to write checks for me if I can't, as well as a power of attorney for healthcare. Even beyond it, that POA for healthcare, many folks are going beyond it with healthcare directives that take into account HIPAA release so that my loved one can actually find out what's wrong with me. To get around that HIPAA barrier. Living wills. What do I mean by resuscitation? It could mean a lot of different things. When do I want my loved ones to be able to pull the plug? I mean, we don't want those issues to be placed on the shoulders of our loved ones when we are incapacitated. And so trusts have specific instructions that help protect your assets and direct your loved ones in the beneficiary role way beyond your departure. We already talked about beneficiaries, the importance of making sure your beneficiaries designations are coordinated with your will. We talked a little bit about joint ownership, that there are a lot of little nuances in joint ownership. And then life insurance can often be the great equalizer, I call, when it comes down to what does fair mean? How am I going to leave the business to one child and then what do I leave to the others? I've already promised my two sons from a previous marriage that they're going to inherit the business. What do I do for my new children from a blended family? Well, perhaps life insurance can come into play. Next slide. Let's talk a little bit about wills, trusts, and open up for some Q&A. How about it? So everyone knows a will is actually a cornerstone of a plan. And why is that? Without a will, the state of Illinois has a will for you. And that is called dying intestate succession. And it may not be anything like the will that you would have written. And so even if it's, you can see at the bottom of this slide, napkin finance. And I don't recommend it, but if you were to write in, if you were of sound mind and you were to write out on a napkin your wills and wishes, and you were to do it in the presence of two witnesses 18 years of age or older, and those were not your beneficiaries, and then you notarized it, witnessed and notarized it, Illinois would call that a valid will. You can't do an oral will in Illinois. Deathbed wills are hard to enforce, but we don't recommend you waiting. I think that everyone should have their wills reviewed. Next slide. Right, that's a copy of another slide. Let's go on to another one. Thank you. Trusts. Trusts. Again, the napkin. Well, a lot of times, in fact, I think I may have had a question from this session already. The difference between a will and trust, and will, really, why would I need a trust if I already have a will? Great question. A will is designed to make sure that your wishes are carried out in the probate of your estate. That's an important concept. Wills are like police officers on a busy intersection. They're directing traffic at the time of your passing. No, you're not on the will. You don't get that. Stop. Yes, you're here. You get that. Come through. Yes, you get the house because it says it in the will. The will directs whatever you own. In other words, what's in your estate. Now, that is a good thing, and it will assure that it will go through probate. And a lot of times people throw out this probate and wonder, well, what's wrong with that? Well, there's three things you need to know about probate. Number one, there is a delay, and that delay is probably a minimum of 6 months. I've heard from others, minimum of 9. Sometimes it can be years. We've heard of cases where celebrities have died with a couple of wills and they weren't notarized and no one knew which will was the right one, and that's still being contested. So there could be a delay. And with a will, probate assures that it's public. Everyone knows everything that you own. They can walk right into the county courthouse and say, I want the books of Greg Pettis, who passed away last week. Well, they don't even ask if I'm related. Yeah, sure, here's the books and here's everything he owns and who's gonna get it. And that's where people make phone calls, and scams are all rampant. So, and there's a cost for the probate. Now, we're pro the legal profession. I work with attorneys on almost 90% of my cases, and they'll charge to probate the estate. So you may have, well, a desire to avoid probate. And so here are will trusts come in to avoid probate, to assure that your money is managed properly after your passing, even in perpetuity. When Ben Franklin crossed the Delaware, he invented a dynasty trust. He said, I'm going to put $5,000 in this trust, and it's designed to pay for the well-being of poor blacksmiths and saddle makers in Baltimore and Philadelphia. That trust, he put 5,000 in. He said, I want 4% interest paid out to these poor tradesmen. It's worth 60 or 100 million. I forgot how many, 60 to 100 million. It's gone on in perpetuity. And now you can do the same with your trusts. We're going to talk a little bit more about specifically, but at the bottom of the trust napkin, you can see it can reduce estate taxes if it's irrevocable. It can avoid probate, revocable or irrevocable. It can control how money is used, both of those, and it can protect from creditors if it's irrevocable. Next slide, please. So let's touch a little bit. Before I touch on digital assets, I'm going to touch a little bit on irrevocable and versus revocable trusts, okay? Two categories of trusts, revocable and irrevocable. Changeable and unchangeable are the two synonyms for this. And there are two phases of trust work, living and testamentary. Most folks that I work with start with a living trust. That is a revocable trust that takes and retitles most of your assets into the name of your trust that you are the trustee of. And the purpose of it is to avoid probate and to streamline the disposition of assets that you're passing. So living trusts are a very powerful first step into the trust world. At the time of death, a living revocable trust automatically turns into an irrevocable, unchangeable trust. But you may also create an irrevocable trust while you're living. Why would I do that? Sometimes in America, it is better not to own something, but to control it. Some business owners and wealthy investors want assets to be out of their federal estate and out of their state of Illinois, state estate tax. I'm going to cover that in just a moment. They want it out of their legal ownership with some control, influence is a better word, some influence over the trustee. This is very common in Illinois, and I'm going to open up for Q&A right after my digital assets slide that's coming up in just a minute. In Illinois, the state of Illinois has decoupled from the federal estate tax program and said, we don't really care what the feds say, because the federal government allows each of us to leave up to 15 million now. The new number since the OBBBA is 15 million per husband, 15 million for a wife, 15 million for any individual, to any number of people or entities without federal estate tax. But the state of Illinois has decoupled and said we're only allowing 4 million per individual Illinois resident, and the 4 million state estate tax exemption is not portable between spouses, as opposed to the federal, which allows the unutilized federal estate tax exemption to be carried over at the death of the first spouse and layered on top of the other person's 15. So basically here in Illinois, you can leave up to 30 million now, and the feds won't attach. It's a big coupon, tax-free, during life and or at time of death. You can use some of it during your life and some of it at time of death. But the state of Illinois only allows 4 million, and it's non-portable. This is very important reason to go to an attorney and have trust work. If you own 300 acres of land in an IRA, you're probably close to right there. If you just have to take a look at your business, and we can help you with that. We'll move on to my last slide and open up for Q&A. Don't forget digital issues. Can everybody see that? I want to make sure that we can, because there's a lot of examples here. This is current. This is really current.
Can't check the chat without leaving the slide.
Okay, that's okay. But in our digital world, it's important that you have a list of all of your social media sites, all of your technology related issues, all of your programs, like your passwords and your IDs, that someone has a list of that. I like what Apple iPhone has done. If you're able to get onto your iPhone while I'm speaking, you can go to settings, Your name is at the top of the setting list. It's got a little picture of you and your name. Click on that. Then go to security, private. I think it's called privacy and security. It's got the word security in it. And at the bottom of that, you'll see legacy contact. Apple, well done. I can actually list a beneficiary of my iPhone and I have 25,000 pictures and stuff in there because I have 6 children. I'm proud of them and I just can't stop taking pictures. And so I didn't want that to go out into the cloud and who knows what happens. I want my iPhone now has a legacy contact. So that's go to settings at the top, your name. You click on your name and it goes to security. Click on that. At the bottom of that page is legacy contact. And so here's a list of other things just to jog your memory. You might want to have a list in your attached, written out next to your will or your trust. Hey, by the way, here's my user ID and my password and so forth. And then last, before we open up for Q&A, but not least, what about the pets? I work closely with our trust department, and one of our trust administrative officers was sitting at the kitchen table of one of our trust customers, and they were signing the trust document for the bank to take care of. There it is. Don't forget your pets. They were talking about, big things, who's going to get what and when and how you're going to write checks for me if I'm incapacitated. Yes, that's right. And all of a sudden she heard a huge squawk from the back bedroom from like an exotic parrot. I wish I knew the name of the parrot. They lived till they're almost 100. I'm hearing. And she goes, ma'am, I'm sorry, but I have to ask you, have you made a provision for this wonderful bird in your will or your trust? And no. Well, as a bank trustee officer, I'm going to be responsible for that bird. And I need to know who in the family can help. So don't forget the pets. You want to designate a caregiver. You can do it in your will or your trust. You can name the pet and name those that are familiar with and love your pet. And selecting caregivers like partners, children, parents, brothers, sisters, people who are willing and able to help take care of that. Let's open up for some Q&A. I don't want to forget, someone did have a good question on how are my WEP and GPOs going to be taxed? I think we should go there next.
That's a great idea.
And so let's go right into Social Security taxation slide, right after the pets.
And one question just popped in from Bob. Do you really need to have anything except for real estate in trust? Shouldn't investment accounts and bank accounts have beneficiaries specified?
That's a good question, Bob. Let's address that. And then we'll go to our Social Security taxation. It depends. And don't you hate when people say that?
Sounds like a diaper.
It does. And as a practicing, member of the CFP board, I have to say it depends, because let's just use an example. With my 6 children, I have 3 children from a marriage back in the 80s, and then 3 from my 35-year marriage today. I'm the father of 6 from 24 to 44. I cannot just leave an asset to my special needs child. James, right in the middle of those. I have tremendous diversity of gifting in there. Right in the middle is a boy who taught me how to parent, really just tremendous guy. But I can't leave him a 1/6 of my estate. I'll disqualify him from, federal Social Security. and the state of Ohio Medicaid program. And he's really loving this, what he's doing. He's employed and has semi-independence. And anyway, so what am I going to do to be fair? If I have 4 accounts and I have 4 children on those accounts, then what about the fifth and sixth child? What about my special needs child? So I've had to create a trust called a special needs trust for James. And it will coordinate with the state of Ohio Medicaid and Social Security, federal Social Security, so that I don't disqualify him. And it's going to help him with his special needs, like Cincinnati Reds tickets and stuff that he likes to do. I hope that answers, because just if you have real estate in a trust, that's great. There are downsides to naming children as TOD and POD on accounts, and though it will avoid probate, it can cause problems if that child, God forbid, has an accident and is sued. If you've got them as any joint ownership with you and a child, it could be that creditor or lawsuit could make that a countable asset in a lawsuit. So you want to be careful. And so there's no cookie cutter answer. Every family's different. And especially when you have a special situation like that.
Terry just jumped in and says, I get that the will is like a policeman directing your assets after death.
Mm-hmm.
What is your metaphor for the trust?
Hmm.
As well as what are reasonable costs to pay to set up a trust?
Very good questions. Is that Terry?
Mm-hmm.
Thank you, Terry. A good metaphor. It would be a committee. A trust is like a committee of your best friends that live on forever. They know you, they love you, they have your best interest at heart. In fact, legally, they are fiduciaries. They have to always do what you wanted. So whereas the policeman is at the intersection for about 12 to 18 months, in a will, he's probating, stopping traffic. No, get out of here. You're not in his will. He has to stick around because you can contest a will for $100, walk right into the Sangamon County Courthouse and say, I contest Greg's will. I swear he told me that I could have his boat. We were boating, but we fished together. He said I could have it. I'm contesting the will. So the policeman has to stand in the middle of the intersection until that will is all cleared up. But your trust lives forever. And it's a circle of friends, is a good analogy. Best friends that live forever. I hope that helps. We have another question.
Do we have another question, or should we go to the Social Security slide?
I don't see any more in the chat. I think we're ready to proceed.
All right. Let's go to our social.
You're going to give them another chance if any.
Yeah, we are. We're going to open up for Q&A at the end too.
Oh wait, there is a bubble in the Q&A, not the chat.
Okay.
Apologies. No, those are just comments.
All right.
However, now back in the chat, can named TOD or POD beneficiaries access my account if sued?
Good question. Let me clarify what I meant there. No. If they're in joint ownership position, so JTWROS, joint tenants with rights of survivorship, yes, they could. It could be attached. Or JTIC, yes, it could be. But no, if TOD and POD, it's only the beneficiary has access at the time of death. Good question, Karen.
Reasonable cost to the trust. We lost that one.
Reasonable cost of trusts. Again, I have to use that D word. It depends. It will depend. I could ask an attorney in Springfield to do A, B, and C, very clear. And then go up to Chicago and ask them to do an ABC. It will be a different price. It will depend on the geography, and it will depend on the expertise of the attorney. I find attorneys, like most of our professions, have generalists that do almost a little bit of everything. And then, it's kind of a surface. They know a lot about a lot of things. They know something about a lot of things. And there are attorneys that specialize in estate planning, specialize in blended family issues, and those are going to be your heart surgeon types, and they will charge more. Good question. I think I would defer the pricing to each attorney here in our areas. Social Security taxation.
And we're going back to the slide.
Yes. How are my WEPs and my GPOs going to be taxed? What a great question. I believe that was Terry. Dr. Borg, thank you again. All right, key concepts. Two phrases, they're synonyms. Provisional income formula, or sometimes called combined income formula. 3 steps. You take your adjusted gross income, I believe it's line 11 on the tax return. You add in all of your tax exempt interest. So if you have muni bonds, municipals, that interest is tax exempt, but you have to add it on top of your AGI. Then you take half of your Social Security benefits, which would include the payments you're receiving on WEP and GPO. Half of that. Add them all together. The total is provisional income, sometimes called combined income, that fits into 3 categories. Let's go to our next slide if we could, please. If that sum of AGI plus tax-free plus half of Social Security is less than 25 for a single individual and less than 32 for a married couple filing jointly, you owe no tax on your Social Security. However, I'm saying 98 or no, everyone that's listening to us today is going to have an AGI plus muni plus half of Social Security more than those figures. So if you're single and your provisional income figure is between 25,000 and 34,000, half of your Social Security is subject to taxation. If you're married filing jointly and you're between 32,000 of this in provisional income combined income formula and 44,000, half of your Social Security is subject to taxation. If you're over those numbers, 85% of your Social Security will be subject to taxation. There is a second prong to this test, but in most cases, it is that easy. So let's keep it simple. In most cases, it is just that easy. You take 0 on the first 25 single, 32 married filing jointly. The money that's between 25 and 34 and between 32 and 44 is hit, half of that Social Security is hit with taxes. And then the money over that is hit with 85. So it is progressive. Next slide. And so here I have a simple pictorial, single and married filing jointly under the 25,000 single and 32,000 married filing jointly provisional income. None of your Social Security is subject to taxation. If you're between those other numbers in the middle, 50% is subject to taxation. And if it's over those numbers, 85% is subject to taxation. Which brings us to, I want to share a couple of secrets. It's in my book on Social Security, the chapter on Social Security. If you're a blended family and you're divorced and you're unmarried, when you hit 62, you have the privilege of calling the Social Security Department and saying, I was married to X spouse from that date, our marriage certificate, to this date, divorce certificate, more than 10 years. I want half of his or her Social Security. It will be without them knowing. It won't affect their Social Security whatsoever. It won't affect their total family Social Security limits. They won't even know. As I said, Johnny Carson had 4 wives. 3 of whom I find it funny. I find it interesting. 3 of them, their names began with J, like Johnny's, and they were married to him for more than 10 years. The fourth one was not. Johnny Carson has had 3 ex-wives claiming off of his Social Security as ex-spouses without affecting his Social Security at all. And he didn't know until later. So my point is this, key things: 62, unmarried, married to an ex-spouse for 10 years or more, you have the right to get up to half of your ex-spouse's Social Security, again, without them knowing. Now, if your Social Security on your own work hours, your own credits is more than half of theirs, then you won't want theirs. You either get yours or theirs, the higher of the two. You can't have both. I also want to say, for widowed divorcees, widows and widowers, if you're 60 and unmarried, you have rights to 100% of your ex-spouse's Social Security at age 60 if you're unmarried, with a phone call to Social Security. And in any audience like this, there's generally 1 or 2 people that are, like an aha, I didn't really realize that. In fact, I'll take it one step further. You're 62, divorced, and claim Social Security from an ex-spouse, and you're about ready to remarry. If the soon to be remarried, if your soon to be next spouse will first claim Social Security from their ex-spouse, or as a widow or widower, if they're claiming when you remarry, if you are collecting before reconnecting, you both can keep taking Social Security from the ex-spouses. But the key is you've got to be both claiming before you remarry. Over age 62, more than 10 years of an ex-marriage, of a previous marriage, etc. These are just a couple of items that are in my book I like to talk about because they're blended family related. I may ask if there's any questions on that, on Social Security taxation, or on the blended family Social Security. That, by the way, that could fit into GPO.
So far in the chat, we still maybe had something left over from previous. Can you give some idea about the price for a trust? I know it depends, but a range.
Yeah,
plan for.
There's a range that's going to be in the thousands, and that's worth every penny if you know that you get what you pay for in most legal interactions. Look, I'm asked a lot, can I not just go online and pull down some trust documents and do it myself? Yes. I can actually cook dinner myself. But if it's more than a microwave, I better have a cookbook and a chef if I'm having people come over. And in my case, if I've got 6 children, one with a special needs, I don't want to do a microwave job. I hire attorney. I hire a CPA. I actually have an investment advisor. I have an investment advisor. I could do it myself, but I'm too tied up with my own, emotions about that. So anyway, that's a good question, but you can do it yourself. It could be okay for a young couple with no children, just got married, go out and get that trust online. But when you start talking about the responsibilities of assets that are in the family, that have some size to that, some complexity, you have individual situations where children there needs to be some restraint and some boundaries in today's world to protect the assets you've accumulated in the event of divorce or creditors or worse. And you should really have paid to have it done. It's in the range of thousands, and it depends on how complex.
Here from Jessica, I receive a pension from the state of Illinois. Would that be subject to tax?
No, the state of Illinois.
And then just generally, are pensions also taxed?
Generally, yes.
But the state of Illinois is not.
That's right.
Okay. That's Another shout out for any more questions in the chat. I'll look in the Q&A. I see no bubbles.
Well, I wanted to touch on the one big beautiful bill. Let's call it HR1. How about just be
All right.
apolitical?
We've got another slide then.
Because, and I don't have slides on this, but I would be willing to come back with slides. I'm doing seminars across Illinois. It's a hot topic. I want to give you 5 or 6 takeaways. If you've got time, everyone, it's 11. I've got time. I'm going to give you these for 15, 20 minutes. How about? 1, the OBBBA, I'm going to call new tax law. It made permanent the lower tax brackets that we've had for these years from 17, from the Tax Cut Job Act. Tax brackets were going to be sunsetted back to pre-2017 rates, which would have made all of our tax rates jump 2 to 5 percentage points, depending on where you are in the brackets. For example, we have a lot more room in the 10 and 12% tax brackets. And the 22 used to be, today's 22 was going to be a 25 or 28. The 24% bracket now goes to 400,000 for a married couple. That's a lot of room. Why do I say that? Because this might be the 4-year window that you should consider doing Roth conversions. Why? Tax rates are down permanently. Let's use permanently in quotes. Nothing's permanent but death, right? But they're saying these are going to be permanent until the Congress and the president can change them in the future. You've got about a 4-year window, at least 4. Secondly, is that the standard deduction, which 85% of us on this call are taking the standard deduction, has been reset at $15,750 for single and $31,500 for married filing jointly. Nice pop. It was going to go cut in half. It was going to go down. Now, in addition to $15,750 for standard deduction for singles and $31,500 for married filing jointly, if you're 65 and older, singles get an extra $2,000 on your standard deduction. Married filing jointly, $3,200. Wow. And in addition, if you're 65, this is a temporary 4-year window, is the bonus senior deduction. On top of the extra, on top of the nice standard, you add these all together. If you're 65 and older and making less than 75,000 single, you have an extra 6,000 standard deduction. If you're 65 and older and making under 150,000 married filing jointly, you have an extra 12,000. So let's do the math. Standard deduction that's been permanentized, $15,750 for single, $31,500 for a married couple. If you're 65 and older, you get another additional $2,000 for the single, $3,200 for the married filing jointly. And if you're 65 and older, there is another bonus on top of that. Now that bonus is only a 4-year window. It's only for 4 years of taxes. Standard filers can add another 12,000 if you're a couple, 6,000. So now do the math. It's 23,700 for singles and 46,700. It's 23,750 for singles and 46,700 potential for 65-year-olds filing jointly. Well, now I can do a Roth conversion. Wow. Wow. Now I have a little wiggle room in my tax brackets. And I can't speak enough about the Roth. I'm not going to default to say everyone should have a Roth conversion, but it is, if you do a survey of everyone on this call and I asked you, where do you think tax rates are going in the next 5 to 20 years? I think we're going to get a majority saying probably up. Okay. So if I've got nice brackets for 4 years, at least 4 years, some of the lowest brackets in our country's history. When I was in high school, the marginal tax rate was 75%. It's 37 today. If I've got low known brackets, why wait till my required minimum distributions age 73 or 75 and be forced to take distributions into a bracket I don't know what it will be one day? Why not convert some of my qualified money that is pre-tax into Roth IRAs, and you pay the tax today in today's known brackets instead of being forced to pay tax in some unknown bracket. Okay, there's an area I'd like to come back and talk more about. That's the standard deduction. In addition, we have the ability to do charitable deductions even as standard filers. Now, these have to be cash, and it's not a huge deal, but it's above the line. It's above the line. And that is 1,000 for singles and 2,000 for married couples. Charitable deductions off the top of your AGI before you get to the AGI. That's nice. That has to be cash. It can't be goodwill and stock or anything like that. How about automotive deductions? If you purchase, the interest on a loan to purchase an automobile that was finished in the United States of America, its assembly was finished in the United States of America, you can deduct up to $10,000 of your loan interest on new automobiles for personal usage, even if you don't itemize. Wow.
Okay, we got a few questions coming in now.
Sure.
One from Mr. Williams, we have a Roth. Is the conversion very different?
Let me ask for a little more clarity. We have a Roth. Is the conversion very different? Yes, good question, Doug. Any wage earner of any age in America can put up to 100% of their income into a contributory Roth up to $7,000 per year. Unless you're over 50, you can do 8,000. Now, why do I emphasize any American of any age? If you have a business of any kind and you have children, why not hire them to sweep the hall and do the filing? Pay them a wage and let them put that in a Roth and be millionaires by the time they're 40 or 50. Wow. There's an idea for your businesses. But I just want to make that clear. That's a contributory Roth, Doug. Up to 7 if you're over 50, it's 8 per year. You don't get a deduction on the way in, but every bit of the growth after 5 years is completely tax-free no matter how big it gets. Wow, I like that. If I'm a farmer in Illinois, I go down to the seed store and the John Deere store, and I buy a John Deere and I buy some seed, and I get a tax deduction for my expenses. Then I put the grain in the ground and it comes in a beautiful crop, and I've got all these bushels of corn, and it's all taxed. That's a qualified plan. That's a pre-tax plan. That's like a 401 or a 457 or all those deferred comp programs. I think if I had a choice as a farmer, I'd defer the tax deduction on the seed and the John Deere, and I'd go for a tax-free crop. I like that. That's what a Roth is. But that is different. A contributory Roth is different from what I just said, a Roth conversion. The contributory Roth has limits when you get to a certain wage. You can't have a Roth contributory. But a Roth conversion does not have income limits. So everyone on this call could basically sit down and do an analysis, which is what I do, is I sit down and analyze. Would a Roth conversion be appropriate for you? If so, how much? When? because we could do Roth conversions every year for the next 15 years. And we could do what's called bracket efficient Roth conversions. I could help fill up your bracket to the 12, fill it up to the 22, fill it up to the 24. I'd work with your CPAs to do that. So that's a good question. Hope I answered it, Doug. You have a Roth, yes, and the conversion is different.
Yeah, we got you from Douglas.
Okay.
Next question, cash charity deductions. Can we do the giving via credit card?
Yes, yes, that's a good question. Credit card would be accepted as cash.
May as well get those frequent flyer miles.
There
right?
you go. There you go.
Okay, and then we got a thank you.
You're welcome. And by the way, as we're on to charity, some of you are interested in value-based planning. You have entities you believe in. You've been founding members and devoted followers, science, medicine, education, religion, whatever. And some of you have a will that says, at my departure, I'm leaving 5% to this and 10% to that. Why wait? You have the privilege of reducing qualified retirement plans. Let me qualify that, excuse me. Once you roll it over to an IRA, so you roll your qualified plan to an IRA, no tax. You can then do direct gifts from an IRA to a charity with you having no negative tax consequence. And it will fulfill your required minimum distribution. It's called a QCD, Qualified Charitable Distribution. Currently, each of you have the privilege of taking up to, and I'm not recommending that whole amount, up to $108,000 a year directly from an IRA to a charity to satisfy your required minimum distribution, and you get hit with no taxation. It's not a tax deduction, it's a wash. It's as if you didn't touch it. You were going to leave it to the organization when you died. That's great. Why wait? You can help advise them. Hey, I'm going to send you 100,000 this year or 10,000, and I'd like you to consider new carpet in the hallway, or I'd like you to have endow a scholarship at my alma mater. I'll keep this up if we can work together. I mean, you have some influence. Just to food for thought. It's called a QCD, and I would help to work with you and your CPA to make that happen if that's important to you.
Well, I have a question now.
All right.
Is there a difference between a Roth IRA and an IRA? Because you've used that.
Yes.
Those terms.
Very good question from Brian. Is there a difference between a Roth IRA and a traditional IRA? Very, very, very good question. Yes. Traditional IRAs can be deductible depending on whether you have a plan at work or your spouse has a plan at work and your wages. You could get a deduction, like the farmer with the seed analogy, okay? And then on the way out, you get hit with ordinary income tax on everything in an IRA. It has no basis, no tax basis, zero. And at age 73 now, you have if you're born later than 1960, if you're on the call born over beyond 1960, if you're younger than that, it's 75. By April 1st of the year following the year you're 73 or 75, you must start taking a percentage of your IRA, traditional IRA. It's called a required minimum distribution. It forces you to take income you may not want or need. It also forces the AGI up, which can hit you with income-related monthly adjustment amounts on your Medicare payments, Part B and D. It's not fun to lose control of your tax paradigm at age 73. You weren't planning on it, you didn't want it, but here they're making you take it. So that's where the QCD can come in, a qualified charitable distribution. If you're 70 and a half, you can do a QCD. Something to talk about. Good question. So the Roth, you don't get a deduction on the way in, and it's tax-free on the way out. On a traditional IRA, these are contributory plans. You get a deduction possibly on the way in, it's taxed on the way out, and you're forced to take distributions but not in the Roth. The Roth never forces you to take out money. Okay? Don't want to ramble. I know it's 10 after 11. QCDs must be over 70 and a half, Bob, Steve. I see. Steve, you must be over 70 and a half. They didn't bump the QCD age up to match the RMD required minimum distribution age. Good question.
Okay. Contact information slides. We'll be getting that information out to everybody. We did have a large number of folks register. We're hoping to work through, hope they didn't have any technical difficulties, but thank you so much, everybody, for joining us today. If you do still have some questions, you can always reach us. I'm gonna put it in the chat at suaa@suaa.org.
And Greg, you were also saying that for those who were registered and attended, they can
Yes.
also get a free consultation or something along
Yes, that's
those
right.
lines?
Thanks, Thomas, for reminding me. Is anyone that's on this call, or anyone that belongs to the SUAA, I would offer a no obligation, no cost, 1 hour chat, just to get a feel for what it is you're looking for, what kinds of advice do you need, how complex is it, and you can call me at my 217-415-1604. 217-415-1604.
Just put it in the chat.
Thank you for your attentiveness. I appreciate the privilege of doing this, Brian and Thomas and SUAA.
Thank you so much, Craig. Obviously, everybody have a great day. It's 11:11. Make a wish for good financial planning. Thanks, everybody. Have a great day.